Thank you, Sam. And thank you, Russell Sage Foundation. Also, I want to thank Dr. Gooden. It's been a pleasure working with you on this important issue. And thank all of you for joining us today. So I have about 10 minutes to really do something that would take days to do a completely adequate job. This is actually an extremely important case, but trying to figure out the exact contours is close to impossible. It reminds me of Brown a little bit, and I'll just say a little bit about that later on. But in the Brown case, the Supreme Court wanted to know, what did the 14th Amendment say about segregation in the context of education? Now, as you know, Brown was directly confronting the Plessy legacy. And the court made reference to that, and I'll come back to that. But after extensive research, the court said it was too difficult to decide. Clearly, it had some impact. Clearly, the 14th Amendment has some reach, but its exact reach was very hard to reconstruct. So the court went on to define 14th Amendment and Equal Protection Clause in relationship to Brown without trying to anchor it in the history of what people were thinking and doing when the 14th Amendment was actually adopted. Also, last night I was thinking about this panel and reading Isabel Wilkins' new book, Caste. And those of you who haven't read the book, I highly recommend it. But she goes and starts the book off talking about basically old houses and pathogens that actually lay dormant for decades, if not centuries. And she argues that, as most medical people would, that most pathogens are not destroyed. They can be contained, they can be managed, but in the right conditions, they come back. And again, I think it's a useful way to think about the history of this country. We think about the founding of this country, the imprimatur that puts on the country. We think about the history of colonialism and slavery, enslavement. And Plessy plays an important role in terms of that history. So let's talk a little bit more about Plessy. I think most of you know now that Plessy was what's called an octoroon. That was actually a census category at the time. He was 1/8 African-American, 7/8 white. And Louisiana had passed a law. And the law that Louisiana passed was equal but separate, or equal and separate. It got changed, the phraseology got changed by the court. It became known as separate but equal. And it's actually also interesting to think about the context of this case and the 14th Amendment and the 13th Amendment was actually debated in the case. The United States had come off the Civil War, which still remains the largest war in US history. More people died in that war than any war since. The country was really going through radical changes. Lincoln had been killed, and we had what Eric Foner called a second beginning of the United States. And so the 13th, 14th, and 15th Amendment was reaching to actually create something quite different. It wasn't creating it in a vacuum. It was creating it, in a sense, in response to what had happened. And if Plessy's not the worst case, is one of the worst, but is in part responding also to another case that may be the worst, and that's Dred Scott. And in Dred Scott, Chief Justice Taney famously said, Blacks, free or otherwise, had no rights that whites had to protect or recognize, and they could never be part of the political community. So this is 1856. So already there's a very strong statement from the court that Blacks are separate and apart, at least socially. And it's interesting. So then comes the Civil War, and shortly thereafter, the 13th, 14th, and 15th Amendment. And among other things, those amendments, especially the 14th Amendment, was meant to actually overturn Dred Scott. So they were meant to say, Dred Scott got it wrong. Blacks can be and are part of the political community. They are citizens. They have all the rights and privileges associated with citizenship. So this is a radical break, potentially. But then when the Supreme Court gets the case, and it's one of the first times it's interpreting equal protection, certainly in the context of institutionalized segregation. And Sam said, especially in the South, segregation and white supremacy already were very much in place. Jim Crow was already very much in place. But at least in this context, the Supreme Court had not put its imprimatur on this. What I want to suggest is that we're dealing with complex interactions. Clearly, the country was segregated. Clearly, Reconstruction had ended. Clearly, Jim Crow was actually being grounded into the country. Clearly, white supremacy was raising its head all over again. But still, the Supreme Court putting its imprimatur on it was of huge significance. And so the court, first of all, defined equality in a very narrow way. It talked about political equality, legal equality, and social equality. And it basically said requiring Blacks or coloreds to ride in different boxcars than whites was about social equality. And it argued that equality under the Constitution could not reach social equality. It had no ability to reach social equality. It also went on to say that as long as they were equal, that there was not discrimination. Blacks complained that this was actually a stigma. This was subjugation. The court responded by saying, if Blacks had that interpretation, that was just in their mind, implying that it was a psychological position, not a real position. In some ways, the most important part of Plessy is also the famous dissent by Justice Harlan. And Justice Harlan, who by many accounts, a very complicated person, he had owned slaves. In the case itself, spoke to the dominance of the white race. He spoke about whites believe they're dominant, and as long as they follow their own principles, they probably would always dominate Blacks. So even so, he had the most liberal member of the Supreme Court. In some ways, I would say one of the most liberal jurists in US history, who accepts as given white dominance. But having said that, he felt like it could not be enshrined in law under the 14th Amendment. It's also important to remember that Justice Harlan, probably the most cited justice in US history by both left and right, and associated with the phrase colorblindness, Justice Harlan believed that segregating Blacks and whites on boxcars, on trains, was not just a violation of the 14th Amendment, but also a violation of the 13th Amendment. There was a badge and incident of slavery. I just got the 2-minute warning, and I'm just in my introduction. But to speed ahead, let me just say this. We are actually in a place where the reach of white supremacy and continued segregation is replete within the United States. It's no longer subtle, it's explicit. I think Dr. Davis will talk about this. The case was not just about separating Blacks and whites, it was also defining Blacks and whites. Plessy had a huge role in terms of our understanding who we are, who's white, who's not white, who's Black, and those debates continue. And then finally, I'll just say in closing, is that the symbolic significance of separate but equal, which wasn't completely overturned in Brown, lives with us today, so much so that much of our arguments are still about separate and equal. The court in Brown, as you know, in Brown 1, said we're going to assume the material conditions are equal, and then that separate is by itself a violation of the 14th Amendment. We haven't practiced that. We still have separate schools, separate housing, separate church, and we still are struggling around who we are as identity. And we can't understand that without spending time with Plessy versus Ferguson. Thank you.
Well, thank you, Professor Powell. Uh, I will start by reiterating your point that Plessy v. Ferguson was not a commencement, but a confirmation. And more than anything else, what Plessy v. Ferguson did was to constrain the 13th and 14th Amendment, which itself had the effect of constraining the 15th Amendment. So your comment about our arguments today being very much traceable back to Plessy and even beyond that is very much well taken. The point of my paper is that Plessy v. Ferguson was about more than race. It was about personal identity. And in that regard, its reach continues to be with us. And it's an insidious reach in the sense that the common reading of Plessy always takes us to separate but equal in regard to race, but overlooks the fact that the central reasoning of the case extended state power over personal identity. And in doing that, it allows and continues to allow states to determine who's who, which is an extension of slave law, which in fact allowed states to decide identity to the degree that it could decide that some human beings were not even persons at law. And so today, as we look at a variety of questions, we have the sense that this state power, which is exercised arbitrarily, reaches into issues from voting rights to who gets to go to what restroom, to who can participate in what sports. And so the personal identity issue is one that needs to be addressed. And in that regard, it reaches state power. And it reaches the degree to which state power can override individual autonomy. So one might consider that the basic question in Plessy v. Ferguson was, who was to get to say who Homer Adolph Plessy was? Did he get to say who he was, or did the state get to determine who he was? And further, could the state delegate to others to identify who Plessy was? And remember that what we have here is a collusive case, that it was a made-up case to test the 1890 law. Because looking at Plessy, who could determine who he was in regard to this binary that the state had determined, that either you were white or you were not white? And there, when you consider that Plessy was not identifiable, and this plays into that long continuum about the question of passing, which is rich in US literature. He had to be identified to the conductor to create the challenge that carried the case forward. So we are at a point now where we have continuing, almost riotous discussions about individual identification, whether we're talking about sexual preference, whether we're talking about transgender, whatever we're talking about is a question of who gets to determine what a person's identity should be. Is this a situation where we are routinely asked to identify ourselves in some context, but in doing that, we're asked to check a box where someone has already determined what the label of our identity will be? And so in that regard, the Plessy question is one where we ask, who am I, right? Who do I get to be? Do you determine who I am? What about the complex of identity? Because we all carry multiple identities. We have identities in varying contexts. And so who is to determine what my identity is at any particular point? Slide, please. So we are in a situation where, does the state get to say who I am? Does it get to say who I am over and against who I say I am? Slide, please. So what I urge here is that we consider the personal autonomy elements that persist in the Plessy decision, and the personal autonomy elements that the United States recognized really runs against what's happening globally. And here we can look particularly at the European Union. Slide, please. Where there are protections for what are recognized as essential human rights, which the United States does not recognize nationally, which the United States has left to each state to determine individually, which has created a circumstance where we have no consistency, where the laws of identity are different from state to state. The abridgment of personal autonomy is different from state to state. Thank you with the slides. So we have a conservative bias in law, which Dr. Powell referenced, and that is law is a continuum, and it has from time to time had significant breaks. The break from Dred Scott to the 14th Amendment was a significant break. We need another break here to recognize the reasoning, indeed the faulty reasoning, that lies at the basis of Plessy to restrict state power over individual autonomy, to allow persons to express their individual identity, to allow persons to express their group identity as they wish, not as predetermined. And here again, I'll go back to, Plessy did not identify himself as Black. He did not identify himself as white. The case that he and his group, the Committee of Citizens, brought forward was a case that was about recognizing the power and the human right of individuals to express their own identity in its fullness, rather than to say that a particular legacy or line of ancestry should be recognized over one as opposed to other, which is at the core of white supremacy, right? That essential binary. And so when we talk about separate but equal, it really is the binary that I suggest people focus on. That is the problem. That is the essence of white supremacy. That is the essence of the us and them problem with which the nation is now struggling. Dr. Powell?
So that was very insightful. It's also very complex. So let me take, you're right in terms of issue of personal autonomy, but there's, Anthony Marx wrote a book called Making Race, Making Nations. And he argues that every nation, in terms of making a nation, also makes an identity. And then of course, you also noted that we have multiple identities. And we can think about a personal identity, but we also have social identities and legal identities. And again, notwithstanding some work in the EU, every country actually is involved in identity making. And so I don't think, so I certainly agree we need to examine this, but it's not simply turning it back to the individual. We do carry our individual identities. We also carry our social identities. And there's also legal identities, even if we get it wrong. Then finally, I guess I would say, as you know, Dr. Davis, in the briefs, in the case, Plessy's lawyers argued that he actually had a property interest in whiteness, and that to take his whiteness away from him without compensation was a violation of the takings clause, due process and takings clause. So in that sense, he wasn't, the construction of whiteness itself is problematic, but he wasn't actually challenging that construction in a sense. He was challenging the taking from him. So
if I may, Dr. Powell, I disagree with that. I think he was challenging the construction of whiteness. And I wholly agree with you about nation states, governments creating identities and the fact that we have social identities. My point is that we here in the United States need to reconsider how the law affects the creation of those identities and which of those identities is reified, or which of those identities is most privileged.
I would agree with you, but I could, and again, I appreciate your bringing this into the conversation. I think the heart of it, and I guess I agree with Isabel Woods on this, is that it's white supremacy and caste. And that if you think of the court today, which has adopted, at least apparently, a colorblind approach to law, it doesn't dismantle white supremacy. So I think we have to be careful, assuming that if we stop labeling people at the state level, which the Supreme Court is actually arguing in favor of, especially conservatives on the court, but they're arguing it in favor of, and I think you actually mentioned this, in favor of maintaining the practice of white supremacy. Yes. So it's not just the label, it's the practice. And the practice is deeply institutionalized now. And race can actually be oppressive, but it also can be liberatory. And so the court, from my perspective, is trying to take away the liberatory aspects of race, not the suppressive aspects of race.
I concur.
So an issue not addressed in any of the paper deals with the fact that at the time of Plessy versus Ferguson, two other constitutional issues were emerging. One had to do with the Chinese Exclusion Acts, and another having to do with the Indian removal and the denial of Indian citizenship. And so I'm going to get both of you to address what does Plessy versus Ferguson have to say, not just about black and white, but about Chinese, about Native Americans, because there was no DNA then. You know, there was no Ancestry.com. So I'm just interested in getting your take on that.
But it seems to me, Professor Myers, that speaks directly to Professor Powell's point about nation states and governments determining aspects of identity overall. And so what the court did in Plessy was to reaffirm the position of the nation state. And here, because of the federal, here in the United States, because of the federal nature of our government, to reify the position and power of governments to decide and determine who was a member of the community and who was not a member of the community, and what their standing in the community was. And so, in a way, Plessy was a confirmation of the government's position in regard to Chinese exclusion. And indeed, Professor Powell spoke to John Marshall Harlan, who was often lauded as a great protector of, who wrote The Great Dissent. But notice what he had to say about the Chinese. I mean, he was wholly in favor of Chinese exclusion. He thought that there was no way that those of Chinese extraction could ever be American. And so this continuation of reasoning that we spoke about earlier is in fact at the essence of the question you raised, Professor Meyer, and that is that the nation state, government itself, has control, has historically had control over the creation and both the destruction of identities.
I would agree. And just add a couple of things. So to just add to what Dr. Davis just said, two things. One, Harlan said the Chinese could never be part of he went back to Dred Scott, right? I mean, that was what Dred Scott, Taney has said in Dred Scott. He did say also, interestingly enough, that Chinese could ride in the boxcar with whites, which is interesting. So he's saying something about them is white, but they're so foreign, they can never be part of the United States. Also, I just want to remind us that anti-miscegenation laws, which started in, I think, the 1690 out of Virginia, colony of Virginia, prohibited marriage between whites and non-whites. And those laws weren't finally struck down until 1967. And so the government has been regulating not just who we are, but it's not just nomenclature, it's also consequential, who you can marry, how you travel. And again, Sam, to your point, the first immigration law limited immigration to the United States.
Whites only.
To whites. So now you have to actually figure out who is white. And there was a case in the 1920s where you couldn't become naturalized citizen unless you were white. And there was an Asian American who argued, who had lived in the United States for many years and wanted to become a naturalized citizen. And went to the Supreme Court, and the Supreme Court said, regardless to what the science say, because he argued he was the original Caucasoid. I'm white. If anyone is white, it's me. And the court said, well, you might be white in some sense, but you're not white in a legal sense. And they denied his petition to become a US citizen, and he committed suicide. So I think to Professor Davis's point, these categories there's not a clear logic to them, and the state plays an oversized role, and they change from one period to the next.
Yes, Singh did go down, and he said, listen, you people are arguing about Aryan supremacy. I am an Aryan, I'm an original Aryan. Don't you people know anything about science? And as Professor Powell just pointed out, the court says, well, we're not really interested in science, we're interested in what we're interested in, and that is, you don't fit our view and our vision. And here, we might talk about something called lookism. And lookism is one of the most insidious of our current forms of discrimination. And lookism is about how people appear and the way in which we practice our relations based on how people appear to us. And so the discussion we have about bullying, for example, cyberbullying and the rest, much of that falls directly on lookism. And Professor Powell, just one thing back to, you referenced the briefs in Plessy. What the briefs were arguing about in terms of the white privilege was the element that the statute had created this false dichotomy, that it had created this dichotomy to provide privilege in a place where the law offered no guidance other than lookism, right? That it was wholly appearance. And Plessy and his group were pushing back against this notion that you could simply look at somebody and decide not only who they were, but as you pointed out, Professor Powell, where they should go, who they should be allowed to interact with, who they could marry. The whole range of relationships went back to that binary, which had no firm basis.
So I just one other thing. We agree that the construction of racial hierarchy started way before Plessy, right? So Plessy did, in that sense, segregation was already in place. In fact, when the United States early on looked at segregation, they actually used the existence of ubiquitous of segregation to say equal protection couldn't mean that segregation was wrong, because that would require restructuring the whole United States. And so, and then of course there's colorism, which, if you think about it, today in the United States, it's against the law, apparently, to actually use race in jury selection and sentencing. And yet every study has shown that the darker you are in a criminal case, the more likely you are to get be found guilty, and to get a harsh penalty. So colorism, which you alluded to, Professor Davis, is huge in the United States. And now it's so ubiquitous that, again, you don't need, in fact, the court is saying you're not allowed to do that, but we're doing it anyway. We're doing it every day.
I want to make the point that we talk about segregation and slavery as if they are not continuous. It's part and parcel of the same thing. I mean, both are bottomed on white supremacy. Both are bottomed on the subjugation of those who are considered to be non-whites. And it's not as if segregation followed slavery, which is a position that people often fall into. Segregation pre-existed the Civil War. It pre-existed the 13th Amendment. Segregation is part of slavery. Slavery is part of segregation.
Just if I can add, I agree with you. I oftentimes remind people that segregation is not simply separation of people. It's actually segregation of opportunity. It's opportunity hoarding. And in the South, you didn't have physical spatial segregation in the way that you had in the North, because you didn't have transportation. The enslaved people on the plantation needed to live close to the big house. So you had social segregation, but not physical segregation. But yes, these are complex systems. And again, the expression of physical segregation in terms of geography was most expressive in the North, not the South. But in the South, you still had social segregation, even though you had people in close proximity to each other.
I'd like to thank both of you. We've had really intriguing and stimulating conversation. We're going to take a very brief break, and Professor Powell will then lead us into the second panel, which will address education.
Thank you much.
Thank you, Professor Davis. Thank you, Professor Myers.